Hi everyone, welcome to Lecture 17. In this lecture, we're going to talk about community-based supports and implications for service providers. And when we're thinking about who's a service provider, it can be many different people. It can be people that provide supports through something like the Wyoming DD waiver. It could be where include housing places for folks, so maybe community or group homes. It also can include places of employment. So this really is important to think about when individuals with intellectual disabilities start getting older, because they'll start to interface with these types of support providers and service providers a little bit more. So first here, we're going to talk about Section 504 of the Vocational Rehabilitation Act of 1973. This is really important because it helped lay the groundwork for providing equal rights and equal access for all individuals with disabilities. It applies to programs, agencies, or organizations that receive federal financial assistance, so anyone that receives federal funds, and it protects any individual who has a physical or mental impairments. So mental also can, be things maybe like ADHD or anxiety or depression, that limit one or more major life activities, and they have to have record of having such impairment. So the Section 504 services cover all individuals with documented physical or mental disabilities, and these accommodations can be provided in the workplace and also in college. And so but also 504 plans can also impact individuals when they're school age. So what I'm going to do is just show you guys, a lot of times I get questions about what's the difference between a 504 plan and an IEP, which is a really good question. So we're going to click on this link here. And what this graphic does is it provides a really good understanding of the difference. In general, you might hear people say, oh, a 504 is like a light IEP. And that's true in a lot of ways, but it's also very different as to what the law that protects it and the services that can be provided. Again, an IEP allows children access for special education, and a 504 plan allows them for access of learning. 504 plans, again, are protected under Section 504, and IEP, when we talk about IDEA, that's the legislation that does that. Both have no costs. What a 504 plan does, though, is really provide accommodations. And these are things that can be like testing accommodations, like extended time, separate location, seating options, like being, seated closer to a teacher, possibly having access to notes, extended deadlines when necessary. And when we're looking at an IEP versus a 504, IEP provides those accommodations, but additionally also has to provide special education services, so it's this specialized instruction piece, and 504 plans don't have that. Again, like I mentioned, the law that's covering them is different. And again, there are requirements, so you do have to have a disability. With an IEP, you have to meet a disability category, and it's a little more specific. And again, we need to see that there's impacted learning or access to their education, not just learning. That also can mean social, emotional stuff. But again, individuals might get a 504 instead of an IEP if they're doing really well academically, and they're maybe also doing well social, emotionally, but they just need a couple little tweaks accommodation-wise instead of specialized instruction-wise to have access to their education. Again, it talks about the evaluation piece, who creates them. Again, it's got, it needs to be reviewed and revised a little bit different. You can resolve disputes through due process and mediation hearings. Again, there's absolutely no cost for the families for these. And states get additional funding, though, to implement IEPs. With 504s, they don't get that. But again, if programs or schools don't comply with Section 504 and identify kids that have disabilities and determine whether or not they need 504s, funds can be taken away. So if you're interested further, feel free Yes, but no, right, not right now. But I would, you can take a little bit further look at that chart. Especially, I know a lot of you have mentioned that you have family members or children or work with individuals that might have IEPs. So if you're interested in the difference a little bit further, that's a good place to go. But again, the main take home message is that a 504 plan just provides accommodation. It allows access. IEPs also have accommodation in the access piece, but also provide the specialized instruction. And they're covered by separate pieces of legislation. 504 plans are not considered a part of special education. They're general education initiatives. All right. So let's look at for individuals with disabilities, probably one of the most important pieces of legislation, especially for adults, was the Americans with Disabilities Act of 1990. And what that did was provide protections for adults with disabilities, particularly in the workplace, which was really, really important. It extends to both public and private settings, and it impacts employment, public services, transportation, public accommodations, and telecommunications. So what I'm going to do now is we're going to watch a clip from the news in 1990 when it was first enacted. I think it really helps kind of explain kind of the tone of the country, what was going on at the time, and why it was so important. Apologies. I had queued this up ahead of time so you guys wouldn't have to watch the ad, but it looks like we still have to watch it again. So yeah, when you are going through this, just kind of think about the importance of this for individuals with intellectual disability. Oh, looks like I have to hit play in order for it to keep going. The importance for this for individuals with intellectual disabilities as they get older and want employment, which we're going to talk a little bit about later in this lecture about importances for that.
It's being called the Emancipation Proclamation for the Disabled. With President Bush's signature tomorrow, it will be against the law to discriminate against disabled people. Against the law not to give them access to public accommodations. Disabled activists say it's not only a question of fairness, but also good business. That millions of disabled people now receiving government assistance will instead be able to work. But business groups are worried. They say the new law is so sweeping and so vague that companies will face an impossible choice. They can either spend big money to accommodate every disability or risk being sued for not living up to the law. As so often in the civil rights area, simple justice never ends up being that simple.
It's dangerous to ride in the street. And I believe it's also illegal, but there's nothing I can do about that. The sidewalks don't have curb cuts. If I want to participate at all, if I don't want to get so depressed I'm suicidal, then I have to be able to get to a bus. I have to be able to get out of here. I don't feel that I'm handicapped by my disability. I feel I'm handicapped by the steps and the curbs and all these things that a lot of people just don't even see every day. When the restaurant owner, for instance, sets up the chairs in the morning, he's thinking about the average size person getting through between the tables. It's frustrating because it's not that he's purposely being mean, it's that he's not thinking.
What will happen is that a proprietor will have to think about people with disabilities. And for an example, all new construction in this country shall be accessible from the day on that the president signs the bill. This law will create an intra and interstate telephone system for people who are hearing impaired and deaf. Each person in the United States will have a 4-cent increase on their telephone bill. That will pay for this entire system. The train system in the United States will be accessible. All buses in this country will be accessible to people who use wheelchairs. 30 days post-enactment of this act, any new solicitation made from any community within the United States for public buses will have to be buses with lifts on it.
Greyhound, for instance, doesn't have any lifts on their buses. I can't take a Greyhound bus over to see my grandmother in Arizona. At this point, I can't take the train over to see my grandmother in Arizona unless I want to buy a sleeper car, which is a lot more expensive than just buying a coach ticket.
Well, ADA specifically completes a prohibition of discrimination against people with disabilities in the area of employment.
The individual business person is now subject to lawsuit. That's the only thing that's changed. And Congress has now passed another body of law, vague, well-meaning but vague, that is going to create a lot of court cases. There is a line in the bill where they supposedly assure us by saying you cannot be forced to remodel your plant under this law if it's an undue hardship, quote unquote, undue hardship. Would you define for me an undue hardship?
It is a flexible standard. It is so the small business does not get penalized more and the large business get penalized less. It is a flexible standard to look at the size and nature of the business and flex with that business.
This company in particular is vulnerable. It has a multiple-story building with an elevator not adapted to passenger use. It has ramps, but the ramps may not be located properly. It has telephones, but the telephones may not be geared properly for the handicapped. I can only guess. I am not willing to let a court determine that, but this law leaves it wide open. Again, a celebration by the American Trial Lawyers Association.
There will be litigation. Rights without remedies are meaningless. But the main purpose of remedies in civil rights litigation is to encourage voluntary compliance.
If by the mere bringing in the handicap in your operation exposes you to a much greater body of lawsuits, this could create many employers to begin to develop a strategy on how don't I hire the handicapped.
The beauty of this law is the flexibility of the law. And so unless I walked into your business, I couldn't tell you what you had to do.
This is the Declaration of Independence and the Emancipation Proclamation and the Civil Rights Act of '64 all roll into one for people with disabilities. Because since the dawn of civilization, people with disabilities have been regarded as less than fully human.
It's going to change people's way of thinking so that we are seen as a group of citizens with rights, just like everybody else, as opposed to a separate group of people who need to be accommodated here and there. I mean, we'll just be part of the population.
While it will not instantly solve all of the problems of Americans with disabilities who are adults today, it will definitely benefit to a far greater extent our children and our grandchildren and all generations to come.
All right. So I think
Advil liquid gels works.
I think it's nice for you guys to see, what the feeling was at the time regarding this. And you saw a lot of people that, really supported it and those that didn't. It's important to note here, I think this is a nice time when I talk about this, to notice when you're out in your own community or when you visit places of employment, how accessible do you think they are? If, for example, just talking broadly about people with disabilities, not just individuals with intellectual disabilities, but are they able to get into a restaurant, not get into a restaurant? Are they able to have access to restrooms? All the same parts as someone without a disability. And I think what's important to highlight here is to bring it back to that idea of equity and equality, and remember that equity is the means with which we hopefully achieve equality. And so what what ADA really did was provide a legal basis for helping individuals with disabilities establish hopefully equality and have same access to things as individuals without disabilities through means of equity, making it so as though they have to do these things that are reasonable. Like they mentioned, the law was a little bit vague. They have to do things that are reasonable. And if they cause any undue, hardship, they don't have to do them. So I think it's always funny to note here, I know not all of you were in Laramie, but just from chatting with people in the community and, working with WIND and folks there and talking about ADA, and after teaching this class, I started to notice some businesses downtown, and in talking with folks with disabilities and folks over at WIND, Actually, one of the most accessible places for individuals with physical handicaps or disabilities is the Buckhorn Bar. So if you have ever been to Laramie, if you live in Laramie, you can kind of, I always chuckle a little bit about that. But just make sure you really understand the importance of this, because it really, like it said, was like the Emancipation Proclamation for individuals with disabilities. It provided a means for equity to hopefully establish equality for individuals with disabilities. So now we're going to talk about some other important pieces of legislation, specifically when we're talking about right to treatment. So in the Wyatt case of 1972, the court ruled the constitutional rights of institutional residents in a group facility were being violated under the 14th Amendment. And what this did was it defined minimum treatment standards for treatment facilities, which is really, really important. And the court monitored them for some time, and it remained, this monitoring remained in place up until 2003. So when we're looking at the minimum treatment standards that were established, it's really, again, important. You see lots of parallels between this and when we were looking at education, looking for that least restrictive environment. You can think about that a little bit similar, and really starting to prioritize self-determination, having control over your environment, having your choices being heard. So individuals who were considered, and this is language from the time, borderline or mildly retarded shall not be placed in residential institutions. Admission to a residential institution should be granted following the determination that the client environment match is the least restrictive habilitative setting. So again, that's that language that sounds like an LRE. So institutions must attempt to move residents in the following manner. So to less structured living environments, from smaller, or rather from larger to smaller facilities, and from larger to smaller living units, from group to individual residences, from segregated to integrated community living, and from dependent to independent living. So this was really, really important, again, at really helping to establish these minimum standards that group homes and treatment facilities had to adhere to for individuals with intellectual disabilities. The Park case we talked about, or the Willowbrook case, we talked about that earlier on in the semester. Again, it's commonly referred to as the Willowbrook case. This video here shows the same one that I showed you guys with Geraldo Rivera and his awesome mustache, interviewing a former resident of Willowbrook. And Willowbrook, again, really brought a lot of national media attention and made people more aware of the deplorable conditions and the lack of programming that existed in some of these treatment facilities. And then also looking at the Claiborne case and its importance with community living. So looking at individuals with intellectual disabilities and where they're living either independently or where group homes are built. So in this case, what happened was this Claiborne Living Center was notified that a special use permit was needed to establish a group home for adults with intellectual disabilities. And so there were all of these barriers that were put into place because they wanted to put a group home for individuals with intellectual disabilities in this specific community. The city council defined, or rather denied, this permit because they didn't want a hospital for the feeble-minded in their community, and it said it violated a local zoning ordinance, and that zoning ordinance said, oh, you have to make sure that you get special permissions and notification, and all of those things. And the Fifth Circuit Court of Appeals ruled that the ordinance was unconstitutional, and the U.S. Supreme Court agreed that the zoning ordinance was a violation of the plaintiff's equal protection rights. So they have a right, because they don't pose a threat to the community at all, to apply for special permits, and they can't be denied for just because people don't want them there. So it was really, really important in helping establish where these individuals could live, again, which is really important for adults that want to be in more community-based settings as opposed to residential settings, so they can have access to things in their community. The Olmsted case, also really, really, really important. This says that states should place individuals in community settings instead of institutions when the professionals deem that that setting is the most appropriate. Here, we're hearing about self-determination. We want to making sure that the person is involved in where they lived, and that must be considered. And community-based services can be, reasonably accommodated. You need to take into account the resources available to the public entity and the needs of others who are receiving disability services from that entity. And so when you look specifically at the Supreme Court ruling, it explained that it's holding two evident judgments as a product of this hearing. And so first it said the institutional placement of persons who can handle and benefit from community setting perpetuates unwanted assumptions that persons so isolated are incapable or unworthy of participating in community life. And we know that that's not true. Second, confinement in an institution severely diminishes the everyday life activities of individuals, including family relations, social contacts, work options, economic independence, educational advancement, and cultural enrichment. So the Olmsted case really started to, I feel like in the legislation, in the way that the Supreme Court explained their opinion, really started to reflect a value system and how we value individuals that have disabilities and that have intellectual disabilities, and they can live in communities and be meaningful contributors to their community and can also benefit from living in their community. All right, so now we're going to talk a little bit about how organizations should handle working with individuals with intellectual disabilities and how they should create systems within an organization, whether that's a business or a more habilitative setting or a residential placement, how they should model their business so it can best accommodate individuals with intellectual disabilities. So it's really important, again, to look at this through this framework that looks at the environmental context of the person as a major factor for understanding his functioning. Again, we're hearing language that's supporting that self-determination piece. These factors can help or hinder adaptive behaviors, functioning, and development. And we know that understanding the ecology of a support service is a prerequisite for effective management. And so making sure that we understand the immediate microsystem around the individual with the disability, the setting of the organization's structure, hierarchy, and culture at an organization, and also the socio-political or macro environmental characteristics by broader society values, rights, and regulations. And also this should be explained within an open system, which means it should be very transparent and open to input from all stakeholders, those with and without disabilities, and really looking at, an organization's mission statement. And a mission statement is a statement of purpose that distinguishes it from others. So this is who we are. Their vision, which is what it hopes to be in the future if their mission is carried out, and then their values. In their values, does it look like they value social equality, human dignity, respect for individuals, freedom of choice, and do they empower clients and employees? So when you're looking at organizations that employ individuals with intellectual disabilities, it's important to see if these things are incorporated into the organization and their business model. And then we kind of want to look a little bit at individualized support plans for adults. So as they are transitioning into adulthood and need support plans, so they can have jobs and so they can function as independently as possible in the community. And so it's important, just like when we're talking about individualized education plans or IEPs, that individualized support plans are optimistic yet realistic. Remember, if our goals are too lofty, individuals can get frustrated. We want to make sure that resources are used to design the who, what, where, when it will be implemented. We want to prioritize our goals. So again, understanding we can't maybe tackle everything at once. So understand what's most important to make this person independent and being able to function in their job. Based on those support needs, which is again that enduring psychological construct of needing something and understanding that. Also making sure we use that person-centered planning, which is making sure we look at the micro unit, so all of the things that are directly related to that individual, which also includes their family. Making sure we're monitoring progress and we're evaluating all of our outcomes. So making sure that our support plan is always continuing to meet the best needs of the client as they progress, throughout their development and throughout and throughout adulthood. So now kind of just talking about quality management. So how does an organization know that they're doing a good job? So this idea of continuous quality improvement is really important. And this, what this is it looking at total quality management involves teamwork. It involves consumer orientation and database decision making. And it wants to make sure that there are learning teams, and this learning team should be characterized by being open to change, so being open to input and constantly monitoring support goals. Continuous quality improvement necessitates right to left thinking, and what that means is, again, evaluating your outcomes and being okay with changing things. So not necessarily just thinking we're going to do this, this is the outcome, and that's just going to be the outcome because that's the way we always do things. When we engage in right to left thinking, we incorporate, again, public policy decisions, socio-political kind of climates, all of those things, and making sure that our organization aligns with those values and values of individuals with disabilities. Making sure that organizations need to be aligned both horizontally and vertically. So that means individuals that are working at the same level, and also top down and down up. So do the individuals at the top, so the CEOs and the people at the very top that are running a business, are their values aligned with those at the very bottom? And that would, a lot of times be more of our individuals with intellectual disabilities. So that's really important. And then again, we want to make sure they're aligned appropriately among all individuals with intellectual disability or people that they're working with. Making sure that the perceptions of the client, family, and staff need to be included and integrated into the evaluation on the quality of service. And state-of-the-art organization design includes both the concepts of the micro unit and the self-managing groups. And again, this is giving a lot of importance to that idea of self-determination piece. So why does this matter? So this graphic should look pretty familiar. We've seen it before. So when we're looking here, we're again talking about public policies that we hope lead to the changes in delivery of practice and making things better in this here. So I think it's really important to remember that as our understanding of disability changes, our core principles change, and they have a direct input on public policy and practice, which subsequently, again, are going to affect our outcomes. And so this is, again, thinking about where organizations fall in all of this. And again, all of what they do permeates all of this. And so again, it's really, really important to think about this. And so after this week, you are to watch The Men of Edalissa, which is a great short documentary that explains kind of what happened to a group of individuals with intellectual disability that worked in an organization and lived in a certain community. And I want you guys to think as you're kind of watching this, where were the barriers located within the individuals in their environment? What were the flaws and maybe the mission, vision, and values of the turkey company that they worked for? And what were the deficits at the systems level? So did they fulfill their promise to the individuals and the community? Did they, increase quality of life? Did they make things better for folks? Were they following rules, regulations, and statutes? So really, really important to have that lens overlaid as you're watching that documentary, and how you can apply the whole idea of making sure organizations have that open system and utilize an ecological framework, and that they also adhere to quality management and continuous quality improvement. So individuals with intellectual disabilities can participate as adults in these in businesses, in places of employment, and residential places that reflect those values. So I hope you enjoy the documentary. Thank you guys for your attention, and we will see you later.